Hi everyone, welcome back to my channel. Thank you very much for joining us. In today's video, we are going to answer all the assumptions people have about lawyers. The eighth assumption about lawyers out there is everything is worth suing for when you have the right lawyer. People have the assumption that everything is worth suing for when you have the right lawyer.
But I think Justice Kuloba, while teaching us civil litigation, he told us you don't really have to go to court with all matters. And actually, as we are now practicing, you realize some matters are just about mediation. Parties are just being stubborn. And as an advocate, you just see. You see, once your client has already instructed you, you can be able to get from this. It's just an issue of maybe egos. You sit down with the parties. At times, even when you have already taking your pleadings to court, you realize that we can have an out-of-court settlement. Yes.
Even sometimes the court itself will suggest mediation. The court itself will suggest it.
So apart from even the matters that have merit, let me tell you, clients will come with you with the most obnoxious or the most out of this world issues. Say for example, someone has someone owes him or her 20,000. They come to you. They're supposed to draft a defense. Then after that, go on to make your pleadings. At the end of the day, the lawyer will charge you more than 50,000. And you're out chasing 20,000. So most of the times, it's okay. Maybe we may not advise the clients because we want the money, but no. There are very many cases that don't need you to go to court. And sometimes even the client doesn't have sufficient facts. Sometimes the case is just some cases are just not exactly just dead on arrival. You look at it and you look like an idiot arguing it in court.
But now people will assume if you give them such an answer, they'll feel like you're not a good
don't
lawyer. Because they assume every case you can go to court.
But I think as a good lawyer, the first thing you need to tell your client is this is the position. You don't need to go to court
because of this.
But if the client really insists, what are you supposed to do?
It's true. And I think even as we move forward, this alternative dispute resolution, it's no longer the alternative. Court is now becoming the alternative. People are now forced now to start with mediation. Even I think in our contracts we start with mediation, arbitration, and then court as the last
80% of contracts it's mediation, arbitration, or negotiation.
So that you don't waste the courts. You're wasting your time, you're wasting your money when you could have just solved it out of court. So court is becoming
also the alternative justice system was it being launched or was it being something like that? So apart from arbitration and mediation, those that are official, like parties are even allowed to make discussions outside the court system.
Traditional.
Actually, even in criminal cases, because we had our plea bargaining week last week, now courts are moving towards if parties can reconcile, how can you compensate parties? Because you see, there's no point. Somebody has committed something and they're in jail,
and you're not being paid as the complainant.
So at times, those are ways that you can
smart way to go about
actually court these days. It doesn't, like for criminal cases, as you say, the complainant really doesn't unless now justice, once the person has been jailed, maybe that is justice for them. But if you look at an alternative way, like the traditional way, if you're in jail like that, they may find ways of compensating the complainant.
In fact, they do.
The cows like that. So they might find more justice from the traditional system than from court.
And you see, the court also looks at what has happened, what is the position of the complainant. The court can't force a complainant if it sees that this person needs to be jailed for rehabilitation purposes. So I think we need to move towards that.
But though I think non-lawyers have the assumption that court is everything.
Court is the if you can scare people, I'll take you to court. Let's read their statement.
I'm calling my lawyer.
But sometimes you to court. Sometimes, as you have said, like criminal cases, someone has obtained like 1 million from you. If they are taken to a criminal court, you're not going to get the 1 million. They'll just be punished. Court is even going to get them because they'll be fined or imprisoned. But people don't understand that because the first thing they do is go to the police station. No, and then by the time now as a lawyer you come in, the case it's already in criminal court. Now it's already too late sometimes. But people should consider the alternatives. 9. Okay, the 9th assumption about lawyers is good lawyers only care about the case, not the person.
No, as a general principle, we were told to detach
from the client.
Yes.
But also we are not inhumane. Like if imagine it's a divorce case, if you realize your client since has a lot of emotions, maybe you first wait or find a solution. Like it doesn't mean completely like you come to an office crying, like you're crying. You'll just be there asking you what happened, not even minding that you're.
But you remember what
hurting.
you were taught, especially for male advocates, that if a client comes and it's a female, or the opposite, it's you are a female advocate and a male client comes and then they start crying, you need to detach yourself from that situation, because a lot can happen that will end up messing you.
And then the client might misjudge the relationship between the two.
Because no, let's say for example you're a female advocate, a male client comes in. Will you start hugging them? Oh, it's okay. It's okay. You see,
I get your point. So this is one of the assumptions that is true.
But I think also,
but it's not only. I think this only is one that's making it look.
But you see, even the reason they're coming to you, then they're emotional. You are supposed to be the objective one.
Yes.
You're supposed to be the
they've gone to a counselor.
Yeah. So if you now start thinking if you put yourself kabisa in the client's shoes, you'll also start being emotional. And you're supposed to be objective,
because how you argue their case if you don't detach
yourself, you won't be objective. You'll say, those are the people you're saying who are shouting in court and being very obsessive.
Because now you feel you need to.
You are being there.
You're acting like you're the one who was left, like the one who's not being given.
Because actually, it's like you're remembering something.
Yeah, it's like you're feeling hurt.
Remember how you were taught we should not represent maybe your spouse or your family. Because you see in that emotions will rise. And actually, this is your co-counsel, but you'll be seeing them as an enemy.
Exactly.
Yeah,
they're being an enemy.
Also, I think even for the less emotional matters. Like sometimes from experience, I had a time where like I could really hardly separate myself from the work. So you find yourself being invested so much, where when you don't get the orders or the matter does not go in the direction you expected, I had serious stress. Like I'd have headaches. Then at some point I told myself, it's a client's matter. As long as you've done your best, because there'll always be disappointments in court. It's not like every day you're going to get yes, because there are days you do a good work and you're disappointed. So it's really good to detach yourself. Otherwise you're going to, even your personal life will be affected by your work, because you're also a person outside your work. So now you can't be home and thinking, how did I go wrong? So you have to detach yourself, do the best work, and leave the rest to the judge or the magistrate.
Plus, you have other cases you need to handle. So to mean you will even maybe be less effective with other other cases. So at least this is the first assumption I see that is 100% correct. I think it's
only. We also care about the client. It's not like we don't care about the client. Because this question is good lawyers only care about the case, not the person.
And you care about them, and that's why you're doing their case and hoping that it goes. You're doing with all your with all that you can. It's not that we don't care. Of course you care about your client. Otherwise you wouldn't take them.
Okay. The 10th assumption about lawyers out there is that lawyers have no sense of humor.
Really?
Is that true?
But we are funny.
It's not.
We make each other laugh.
But it's not true.
Have you read our judgment?
But there are also judges and magistrates.
I think that's where the assumption is coming from. Because they're normally it's either extreme or
like the one for Manita, and there's another one recently also I saw.
Actually, the one also by Kiage.
Exactly.
You know when you're reading it and you're like, oh,
was that?
It's just lovely.
There was that one that was doing rounds. I think it's only seen for Kiage on Facebook. So there are judges who have a good sense of humor, and there are those
and they manifest even in the judgment.
The judgment they actually write them.
And actually, as lawyers, we also have a sense of humor, because you see, with our profession, if you really are too tight, you'll get a
also
breakdown.
that's an unfair comment because
Yeah.
sense of humor is very personal.
relative.
It's very personal.
Yeah.
Whether you're a lawyer or a doctor or whatever, if you have a sense of humor, you have it. If you don't, you don't.
But then someone's
Regardless of your
profession
profession.
aside, personality.
Yeah, as a person.
Yeah. Then the 11th assumption about lawyers is that lawyers have huge egos.
Wow.
Me, that's not true to me.
It's not
I think it's the same thing.
It's also
Personality.
personal.
Yes,
It's not a professional thing. It's a
But
personal
I've heard
thing.
of people
Yeah.
with experiences with lawyers, or even a pupil giving stress to the other support staff.
Yeah.
You cannot tell them anything.
Yeah.
You
But
are
that
killing.
is
Like
true.
there are people who have
That's-
very, very bad conduct.
But
in
they
that
let
sense,
the
yeah.
profession get into their
Yeah,
heads.
true.
And they stop being like doing the normal, being courteous. But then I also remember there's a time when I was in the law firm, one pupil went to the secretary and threw the file at the secretary saying, organize that file.
And that's just a pupil.
Yeah, and that's just throwing it like it almost even hit her face.
Oh my goodness.
Telling her, organize that file.
Yeah, but
Or
then
you
again,
can't
that
tell
goes
me
to the
anything.
personal
Yeah.
That's
character.
a personal thing.
Yeah.
Sure.
I was just shocked. Can you?
Because you can't behave like that only after you become a lawyer or an advocate.
But then you can
That's-
imagine such.
that's
She's
just-
just a pupil. She's
that's
just a
a
person.
Yeah,
you.
actually, if you have a big ego,
Only that
It's
now
not-
the
it's
name
not-
or
yeah,
it's
whatever
not-
will magnify
yeah,
it.
exactly.
Yeah.
But I don't know why they normally judge lawyers. Because only two, maybe someone has experienced only two people, but they know they'll assume.
No, but
it's
the
only
ego
lawyers.
it's actually a big percentage.
yeah.
Oh, you've not had people who like I really dislike being called like wakili or I really dislike, and there are people. Hey,
If you
don't
don't call them,
Cancel.
Ah, yeah, there are people, if you don't call them, they get
Hey,
fired. Jesus
wakili,
Christ.
cancel.
actually, have you ever seen a situation in which you never knew there was a senior in the room and you don't want to address court? I always feel a good senior is someone who will maybe interject or will allow
Be
you
accommodative.
Yes,
Like it's
yes.
not a matter
Then
of life
later
and
on,
death.
Exactly.
realize that he was to introduce you.
Yeah.
But you see, others are like, what is this?
You're being
Junior
disrespectful.
cancels. And you're left like, wow, it was just an honest mistake.
Yeah.
I didn't want to.
Of course, you could not have guessed. Number of years is not
As
written on the
exact-
form.
Yeah, and you don't carry around the role of advocate.
To check.
How many years?
Yeah, because in this generation, you remember how we were in KSL with
Yeah.
older people.
Yeah.
Somebody is 60
By their law school.
and they are
Actually, you find people who've done maybe even engineering.
Yes.
Yeah,
Even
true.
even in our class we had a guy who
Yeah.
a whole engineer,
True.
a whole
Yeah.
brigadier,
True.
like he's a former.
Exactly.
He's had a fair share of his life and now he's back in school.
Yeah.
So you see that's a person you will not know if he's your senior and maybe he's still a pupil.
Very true.
Yeah, but
true.
yeah. So
It's normally just a honest mistake.
Yeah.
The 12th assumption about lawyers out there is that lawyers take too much time. I think they mean with cases,
yeah.
with their matters. I think that's what they mean.
Yeah, but really.
The power is not in our
The
hands.
system. It's a systemic problem.
Yeah, just the way I said earlier, it's very unfortunate. A client comes to you, they tell you, hey, my property is being sold, I need orders. They expect you to sit down, write orders and give to them. They don't know that you're not the one who does that.
Exactly.
You have
You
to
have no power.
sit down, maybe research, maybe it's a unique case because cases are very different. Do your research, draft your pleadings, file. You can even do that in a day. You can do that in a day. File. Now the question comes with the judiciary.
The court is
Yeah.
Sometimes they
Whether
can't
you-
even find
whether you get a
agenda.
date,
Yeah.
can I tell you an example right now? If you're requesting for a date before the ELRC, Employment and Labor Relations, I think the dates are in 2022.
Imagine.
So they are not even giving dates for matters after 2016. After 2016, they are not giving dates because they are dealing with 2016 and. So if you're
Certain thing that
so
will blame you.
So
But
if
they
your
blame
matter
you.
is 2017, they ask you, can you arbitrate? Like we have a matter, we've done mediation. Mediation has failed, so now we're just chilling, waiting for them to finish between 2016 and behind. So a matter when you go to court, it's good to know as a client. That's why it's good to try the other options. Really, not unless it has really refused. then you go to court. Going to court, you're not guaranteed of a quick, even if the constitution says.
You see, once you have filed the application, you've gotten the orders, you need to serve the other party.
Yes.
The other party has to
reply.
Maybe
and
they'll have to
itself,
join another third party.
Yeah.
So if something you thought something was very straightforward,
no.
There's a lot that is involved.
And sometimes they even take their sweet time intentionally. Yeah, they just don't. Okay, in that case, you might have a solution. You can decide to file maybe an application, maybe to just proceed or something like that. But sometimes these people, a good example, we had a matter. The second defendant just disappeared. We couldn't find them until we filed the substituted service. So that takes another time.
This is another
filing. So when we did, they appeared. Now they were available to be
so they did intentionally.
And then after service, now they are saying the summons were expired. Like they are looking for reasons to just delay the matter. And that's beyond you, and it's procedural. You cannot say we'll jump this step. If they come in with an application, it has to be had. And there are people actually who like doing applications after applications after applications. Their advocates who are very good at that. And they will do applications.
Another thing that clients think is that their matter is the only one that is that is another issue. They fail to understand a judge might have 51 cases in a day, and yours is not special.
Even apart from the judge, you as the that is very personal because the frustration sometimes you get from clients, it's too much. You're not doing it's not their client that their file that is running the office. Unfortunately, you have maybe 50, 100 other clients that you need to attend to. So even before, when they come to the office, they expect you to do their matter chapter.
Stop everything.
You have to have other things. You're going to court, you need to make time for drafting. Sometimes you're going out of town, maybe even for 2-3 days, you're not within Nairobi. You just have to be human. Just the same way you as a person cannot be able to do all things in a day. It's the same way an advocate will not be able. And now to add on top of now that time, how time goes, it's not on the part of the advocate. Most of the time. Hata kitu kama deed poll, you prepare a deed poll, someone expects to get it in 10 days and then it goes to lands, you have to wait. My friend, you wait for 6 months, 1 year.
And it's in lunch, there's nothing.
So when you call me, I'll just tell you, I'm following up.
So
and then perhaps the clients will just give money for facilitation.
Actually, that's another issue. Most clients fail to pay their advocates on time because, trust me, we are also in the service industry. And without payments, you can't process 1 or 2, 3. You're given your bill that you need to pay this and this. You now wait, you assume the advocate will now be handling your matter, yet you had an agreement that pay this amount of money or something of the sort. So also as clients, do your part.
And even after the case has gone all through, even you get a judgment, even making good that judgment is a whole process.
They never even say the case begins after the judgment because the execution.
3 years. So you're seeing people the things are being auctioned because now you've gotten a good judgment, you've been given your but now the person can't execute. The execution itself is a process.
Or by bad luck, whatever you wanted to attach,
they don't
exist.
have it. So
people even say
sold their property.
It's not in our hands.
It's really not.
We do our best. Though anyway, there are some lawyers, may know a lawyer who normally takes up cases for the money. Immediately he gets the first deposit, he forgets about that case. Then when now he gets broke, he remembers, in September I had a matter.
That's what you are saying. Now the unfortunate part.
But you see, it also goes back to doing due diligence. I feel it's the same as purchasing some sort of land. You need to do
your due diligence. When you're going to a doctor,
you just don't go to any doctor. You ask who's the doctor.
The 13th assumption about lawyers is that lawyers can't be trusted.
Really?
Trust is a personal issue.
Where are these assumptions coming from?
These are just personal issues. I mean, if I was not honest as a person, there's no way you expect me to be honest as an advocate.
But people get 1 or 2 stories, then they make it as like the blanket assumption to all others.
But unfortunately, for those who assume that lawyers cannot be trusted, you'll still need a lawyer.
Yes.
By then you still need a lawyer.
Unfortunately.
And then you find some people they have not decided because they believe lawyers are not trusted, they go use other brokers or something.
Yeah.
Then they come back when
Yeah,
they're
scammed properly.
Yeah, and as we said, using a lawyer is the safest bet because you can sue a lawyer through the LSK and they lose their license.
Yes.
That's why you find the scammers are mostly not lawyers. Because a lawyer, you lose your license, you have to practice law or something.
Yeah.
Or you are stuck out. Like you don't become a lawyer for like forever.
You can't trust this personal.
But they trust is a personal thing. But people are normally so harsh on advocates. On lawyers. We are the cheats, we are the liars, we are the
Scammers.
You're forgetting thieves.
Yeah.
We are thieves.
The 14th assumption about lawyers is hiring a lawyer will cost you an unreasonable amount of money.
But sometimes it's a worthy investment. The same way we are saying with doctors, you can't really look at what you're paying only. You're not looking at what they're going to give you.
Yeah,
so some people just look at the money you're asking for. They're not looking at what they want, because sometimes what they're asking for, I remember you're saying people are underestimating the kind of brief they're giving you.
Yeah.
So sometimes it's actually not, it's a worthy investment. And
someone
who's looking at the fees really is not a serious person.
And actually, we are guided by us.
By the
remuneration order.
Yes. So you see, it's like you're going to a supermarket, then you find a product on the shelf. You now want to negotiate on that without having to realize there's a standard
regulated.
And it's a crime to undercut.
Yes, to undercut.
But also, I think, sorry. But also, it's not true because of such arguments like the employment issues. A client might come, the client doesn't have money at that time. You do an agreement, you take 30% of the court settlement. So sometimes this assumption is not true, because sometimes you may not pay from the beginning. You only pay the advocate will only take their pay after the case has been done with.
But let me see the assumption that we'll charge an arm and a leg.
And reasonable
Also,
amount.
yes, I would say it is a good amount. It is not unreasonable. Someone comes to the office, they tell you they want commissioning. You tell them maybe 2,000 or 1,000. They say it is just a stamp.
Exactly.
Go to River Road and make a stamp.
Very true.
That's a very, very rude sentiment. Like you tell someone notarizing is 5,000, 10,000. It's just a stamp.
Or actually,
Do they not to be a notary?
Okay, where is your stamp?
Where is your stamp? And where are you coming? The reason you are coming to me is because the service can only be provided by an advocate. If it's something you would have
it's
done
like arguing with a mama mboga because she's charging 20 bob for a banana instead of 10 bob. Nasi ni ndizi tu. Go to another person. You see, it's a choice. If you want to get substandard services, you get them. Because in as much as we are told by our regulations not to undercut, we have people who are very ready to undercut, and they'll teach you the streets proper. You'll start now running to LSK. Oh, I paid him 20,000. What were you paying for? Maybe you're paying for a company, or what the regulations say you should pay 50,000. You see, now at the end of the day, already you begged for a discount, you got it, and cheap. Is mostly expensive.
And actually, people don't understand. We are in the service industry, so people assume that when you're going to court, you're just going to talk.
It's
like you're not using your brain. It's like
they think it's for fun.
Or drafting. We had a client. We did their agreement. After we were done, it was around 3 million. Then they're like, we thought it's 500 shillings. And you're like,
you're buying and not forgetting that's an agreement. In case something goes wrong, they'll come back to you. They'll need you to go and testify on their behalf. Come on, how will I come and testify when you only paid me 500? In fact, I can say I did not draft the agreement.
True. Those are agreements you just stare and tell the clients, no.
People are used to getting legal services from cyber cafes. Where they just go and print for you an agreement, or they print for you something. But by the time you walk into an advocate's office, they are paying rent to be in that office. They are paying their PC. Kwanza,
professional indemnity.
People should know that for an advocate for a certain number of years, mostly the PC for each year is more than 20,000. Now you want to pay 500 for an agreement. I renew my services each year with over 20,000. Okay, not me, but for people with more years of practice. And you expect when you come to my office, it is that piece of paper that I pay for 20,000 that enables me to stamp your documents. Actually, if I'm stamping your documents without having that document, it will be an issue. So you want to come to the office and tell me it's just a stamp. A stamp that I renew with like 20,000, 30,000 every year.
It's just a letter.
Not forgetting the number of years you went to school.
Hey, see this stamp. It's the most common thing I've had. That's just hilarious and just outright.
So nenda kusimama tu kotini.
Even taking someone be like, so unafaa cost 1,000 ama 500. Tunaenda kuongea for that. For less than 2 minutes.
Like, okay, let's educate ourselves, especially for people who've gone to school. I'd expect that from maybe someone coming from the village, they don't know anything.
But trust me, like,
then I can explain to them.
3 million.
But now tell me you're a doctor, you're an engineer, you're a teacher, you're an accountant, you're coming to me telling me, hey,
it's just
you're coming to me, you're looking for a job for 300,000 or 400,000, you want an EACC stamp, you want a commissioning of your EACC documents, you're telling me, it's just a stamp, see Mia.
And for them, they need that stamp for you to get that job.
We have to be serious. Educate yourself on, just like me, if I'm looking for a doctor right now, I know a couple of people who've been mentioned. They are good people, and I do not expect, if I'm going to this certain person, to go and pay a certain amount of money. Or just like buying anything in the market, you can get maybe a dress for 20,000, 30,000, and you can get a dress for 5,000 or 500 bob. So I cannot be walking into a high-end shop, and expect this dress to be like 500. So at least I am aware. When I want cheap, I can go here. When I think I can push my limit, I can go here. So please, let's educate ourselves so that we avoid some very interesting assumptions here. Just a little education goes a long way.
So those are the assumptions we had today. I hope the misinformation out there has been addressed. At least I know it's not 100% addressed, but at least it has given some, like, we have educated most people.
True.
Because these assumptions, others are very crazy, very crazy. And thank you so much for joining us, coming to my channel again.
Thank you for having us.
Thank you for
Always a
having
pleasure.
us.
So, thank you so much. I hope you have enjoyed this video. Thank you so much for watching. Please don't forget to subscribe,
like, comment down below,
and share this video. Until next time,
bye.